Defense interviews are somewhat unique to Arizona. They offer criminal defense attorneys the opportunity to interview officers involved in criminal charges before the case goes to court. A couple of years ago, I made a video with some tips and considerations for defense interviews. The ideas certainly apply specifically to Arizona, but they're also a good refresher for interview considerations generally. So now, here's me from a couple of years ago discussing defense interviews. Today's topic is defense interviews. What officers in Arizona should know. My name is Steve Cerbalic. I'm a panel attorney with ASCOPS in Arizona. Arizona has unique rules that allow a criminal defense attorney to request and conduct an interview of the police officers involved in criminal cases. Today, I'll talk about the legal basis for defense interviews, what happens if you do not cooperate, and tips for a successful defense interview. Know that this is a basic summary, and your department may have additional rules or guidance on this topic. And this is not legal advice, so if you have additional questions, ask for help. The Arizona Rules of Criminal Procedure specifically allow for depositions of witnesses, including police officers, in criminal matters. Depositions are formal processes and can involve substantial costs related to recordings, court reporters, and certified copies. Defense interviews are a lower cost alternative to depositions. They are informal, recorded, and can allow defense attorneys to ask questions of a potential witness, like a police officer, without incurring heavy costs. Now that you know that defense interviews are a low-cost, less formal alternative to depositions, let's talk about what happens if you refuse to cooperate with a defense interview. Because defense attorneys have the legal right to speak with the potential witnesses prior to trial, if an officer refuses to cooperate with a defense interview, the defense attorney can file a motion with the court requesting an order for a deposition. Depositions are conducted as a result of a lawful subpoena and involve the witness, in this case the police officer, giving sworn testimony under oath at a specific time and location. Failure to appear or cooperate with the deposition order can result in fines or even a criminal contempt citation. Now that you know that officers will, one way or another, be required to provide a statement to a persistent defense attorney, let's talk about best practices if you're faced with a request for a defense interview. Generally speaking, if you have access to the report or notes related to the incident, review them prior to your interview. When you answer a question, make sure you are clear that you're relying on your memory as it exists at the time of the interview. Make it clear that if you were given more information to review or if you had more context, your answers might change. Finally, don't overreach. If you aren't sure of something, say so. It's better to say you don't know or you don't remember rather than making something up. So here's the recap. We covered the legal basis for defense interviews. Under the Arizona Rules of Criminal Procedure, witnesses can be compelled to provide a statement to defense attorneys, one way or another, prior to trial. We also covered what happens if you do not cooperate with a request for a defense interview. You will face a court-ordered deposition if the defense attorney is persistent. Next, we talked about some of the best practices for defense interviews. Review your notes. Make it clear that you're answering based upon what you remember, and do not overreach, guess, or make anything up. Finally, when in doubt, ask for help. Defense interviews can be frustrating, and if you have questions, lawyers like me and organizations like ASCOPS are here to help. If you found this video helpful, please hit the like button below and subscribe for more law enforcement lessons. I'm Steve Cerbalic. Thanks for watching and stay safe out there.